to attorneys, children's rights to counsel, and the youth involvement in court hearings. She also is an assistant director to child welfare for National Child Welfare Resource Center on Legal and Judicial Issues. She received her JD from the University of Baltimore Schools of Law in 1997, the BA from the University of Delaware in 1994. Welcome, Ms. Khoury.
And I always kid them because they have on their paper, as they introduce people, they actually have a thing that says, clap now and shake hands with the speaker. And I'm like, okay, we're going to clap and we're going to shake hands. So I appreciate that introduction. I just want to get an idea. Was anyone in the early, we had 2 youth in court sessions yesterday in the morning. Anyone in those? Okay. I just wanted, because there are a couple things that I'm going to go over again, but I just wanted to be sure you know how quick I could go over them or if I had to spend some more time on them. So the Bar Youth Empowerment Project that I run at the ABA is a partnership with the Casey Family Programs and the Eckerd Foundation. And what the Bar Youth Empowerment Project does ultimately is we attempt to improve outcomes for youth as they age out of care. A lot of people know what happens to kids if they do not have a permanent placement after they exit care, and if they just age out in terms of their education, in terms of their health, just in terms of poverty, just overall well-being. And so what we try and do is really increase permanency for kids as they head towards aging out. And so the portion of that project that sort of brings me here today is the one where we're really trying to increase the involvement of youth in their court hearings. As we've traveled around the country, we've talked to youth about court hearings and about the fact that usually they are not involved in those court hearings. And by and large, the kids have told us that they understand that there's this thing called court and there's a person who's a judge, and that they want to be involved in that. They understand that a lot of critical things occur at this thing called court. And so that they really want to be involved in those court hearings. So because of that, we started this project. And I just want to say that kind of the trend used to be that we were not going to involve kids in their court hearings. Court really was not a place for kids to be involved in. You know, the dockets were long and the court hearings were often very, very short. And so we're really trying to change that and ensure that that the court hearings is a meaningful place for youth to be involved. So I just wanted, this is a quote that I put up here that we've heard just across the country is that kids, they want to be heard by the people who are going to decide things about placement, about school, about permanency. These cases are about them and they want their voice to be heard. So as I said, trend was not to involve kids. So when we started to change that, and one of the kind of the first things that kicked it off was the feds passed the Child and Family Service Improvement Act. And what that does is it really places the burden on you. It places the burden on the court. It says that the court has to consult in an age-appropriate way with the child about the permanency plan. So what this sort of told to us is that Congress is now seeing that placing a higher importance on the child's view and the importance of the child's interaction with the judge. Now, of course, what does the term consult mean? And so HHS actually issued a statement because that was sort of an ongoing question. How does a judge consult with a child in an age-appropriate way? And so HHS didn't go as far as we would like, but they did say that it does require the judge to find out what the child's opinion is about the permanency plan, not just what someone thinks is in the child's best interest. So if the permanency plan is adoption or return home, what does the child actually think about this? Again, indicating an importance placed on the child's input, the child's view of it. And so they did not say that they were going to require that the judge actually pose a literal question to the child, and that the judge and the court could gain this information by other means, through a guardian ad litem, through a CASA, even through the caseworker. But it's really imperative that the judge really distinguish that this is the child's opinion about the permanency plan. The only real case that we've seen on this is a family court case that was in New York. And just really briefly, the facts is that there was a teenager, he wanted to come to court. The child welfare agency was going to object and said that they did not want him coming to court because he would often act out after he was in attendance at court hearings. And so they had a hearing on it. And the judge ultimately said that that was not a good enough reason. The judge actually did a great job of kind of going through all of the positives for why it's important to have kids attend their court hearings, and that the fact that the child acted out was not a good enough reason to keep the child out of court. And then he was interpreting the Child and Family Services Improvement Act as well as the state law, and he said that it was meant to be a two-way discussion between the child and the judge, especially a child who was older, that it really had to be engaging between the judge and the child. So that is the only case, at least that I've seen so far, that is on point. In your jump drives, there are a couple articles as well as this PowerPoint, and it really goes into details about what NCJ, FCJ, the ABA, everyone, and these are kind of, you know, the who's who of child welfare and the court, what they have to say about kids coming to court. By and large, they say that at least at critical hearings, children need to be involved in their court hearings. And then this is, I just wanted to give an idea of what other states are doing, and you can take Kansas off the top. That's actually in error, but all of the rest of them, age is usually, and it has been kind of used as a bright line rule that kids over the age of, for example, 14 can come to court unless the judge finds a compelling reason why the child isn't present, and then under the age of 14 also. Another thing that I thought was important is that Arizona is passing a court rule, and I actually talked about it in the previous session, but that court rule says that all kids, regardless of age, has to come to court unless the child's attorney files a motion either in writing or in person, and then the judge has to find good cause. So we're kind of seeing a trend in the states towards involving kids in their court hearings, and that it's ultimately up to the judge. If the judge finds, for example, good cause, or if it's not in the child's best interest, the sort of the choice if the child comes to court ultimately rests on the judge. The other interesting thing, I think, and this is kind of a plug for child's counsel, is that in that court rule, in that proposed court rule, the other portion of it is that the judge has to ensure that the child's counsel has had meaningful contact with the child prior to the court hearing. And so I was actually chatting with the judge who proposed this court rule. And so he's started to ask at every court hearing, ask the child's attorney, have you seen your client? And the first couple of times he started asking that question, no attorney had said that they had seen their client. And all of them were honest about it and said, no, I have not had the opportunity to see my client. And so he pressed on at every hearing. And now, as it's been going on for a while, as his question has been going on for a while, he's starting to see that kids' attorneys are seeing their clients as they ought to be. But so I thought that that was another interesting component of that proposed court rule. But what you're interested in is what is the requirement here in Nebraska. And here is your statute that's on point. Again, the burden is on the court to provide notice of the hearing as well as the right to participate in the hearing. And that goes to 3 individuals: the person charged with care of such child, and then the child's parents or guardians, unless the parents' rights have been terminated, or, and why we're here, the foster child if the child is 14 or over. So again, burden is on the court to ensure that a child age 14 or over gets notice of the court hearing and the right to participate in that court hearing. All right, now I'm going to stop talking, and I want to sort of hear from you all about why you think it would be important for a child to come to court. And what I did was I talked in advance to my 2 former foster youth here about if they could indicate to all of us why they think it's important that they're in attendance in court. And then I want to open it up to the rest of you. Go ahead.
I personally say you always, like, no matter the age kids should go, it's our lives you guys are choosing and putting into play. Like, what you want your kids to go through, and you have to choose everything for their life, not let them see what's going on with them, let them go through that process of knowing themselves. And the fact is, little kids, like, yeah, they don't get too much say out of going to court, but you get that face. You see that kid. We're not a number. We're not a case file. We're a human being like the rest of you are. And, okay. And the fact that, like, kids, like, you can, if you have a kid in the state for so long, like, growing up in the system, like, you see how this kid is maturing, that, like, it was a baby, and now it's 4 years old. And, like, you're just seeing that, like, this case needs to get worked on harder. Like, we need to get this kid out of the system in another placement, some place that, like, it can be stable and there's a permanent residence for this kid. And because the kids that just grow in the system, that grow up in the system, they don't usually have, they don't, how do I explain it? They grow up in the system and they are in it for so long, after a while they just think they're a problem child, and other things come about. Kids start doing drugs, they get into fights, and then you see them on a different court case hearing later on saying, or they raise their own kids the way that their parents raised them because they've just slipped away in the system. And I don't know, I just think, and every kid has something to say, even if it's like you guys just coming up and saying, hey, how's school going? Like, it shows you guys are actually there for us. That, like, showing that, like, we go through caseworker after caseworker after placement, and we just give up on everyone. We're done. We don't want to talk to you. Like, we're tired of telling people our story. We're just done. And having that one person, like, even if it's 6 months till we see you again, but you showing that you're interested in us is more than, like, it means so much to us, to the little pieces that we get every day by someone that we know that don't care.
And we were kind of talking earlier about, like, I had the same judge for the whole 9 years I was in the system. And before my mom passed away, I didn't go to court that often. If it was like deciding whether we're going to go home or not, and my mom was pretty sure we were going to go home, we went to the hearing. After she died, I was involved in almost every hearing that was put in place, and just knowing that the judge that you're going to go see has a place of power. They have power to decide where you go, what you're going to do, what kind of therapy you're going to need, if you still need to go to therapy. Like, what is going on in your case kind of lies in the fate of the judge. And just knowing that, and knowing that the judge wants to see you in their courtroom and just wants to say, hey, how's school? The smallest things do matter to us, because I know I can't tell you how many times I felt alone, not even worth anything, not anything. I'm going to be a nobody because nobody cares about me. But when you see somebody in a place of power that wants to talk to you, even if it's the smallest things, it makes a huge difference. Like, little connections everywhere just means so much to us in foster care. Like, one time I was going to Highview and I was first learning to drive with my foster mom, and I was pulling into a parking spot, and parking is not my best point, but my judge was returning her cart to the cart return, and I was pulling in the parking spot next to her, and I just didn't see her, so I was pulling in kind of fast, and I just about hit her, and now every time I go into court, we have that small little connection. It's the dumbest thing to connect about, but that connection to somebody who has nothing, nobody left to confide in, and if you have that with somebody in power, it just naturally means more to the kid. And I love to go to my hearings, and sometimes, you know, they're only 5 minutes long and everybody agrees and then it's done, but still, you know, being there, knowing that somebody in power wants to see you means so much to somebody who has nothing.
Thank you. And so I want to get an idea, and we are going to talk about some of your concerns about having youth in court, but I just want to get just some ideas from you about why you think it would be important to have youth at your court hearings. Anyone have any ideas?
I think just the idea of a child investing in their own future and having a say with regard to what goes on in their lives, I guess that's the empowerment thing. The other thing is, in my court, we've started doing that more and more, getting kids in, and it really makes a difference to me to lay eyes on these children. And just like that first young lady said, they're not just a name in a file now. They're actually a viable person whose life we're impacting in a very large way.
Excellent. Other thoughts? Yeah.
My experience is that a lot of times the kids will say something in this situation that the parents have never heard before. I mean, I had an incident, and excuse my French because I'm going to quote it, but I asked this young lady, she was mid-teens, I asked her if she wanted to tell me anything, and she did for the next hour and a half. And every time she kind of caught a breath, I'd say, well, I think what I'm hearing is this. And she said, well, you're fucking half-assed listening. And I just kept letting her go. And I knew it was things that her mother had never, ever heard. And so I just let her go.
And I'm sure that meant a ton to her to be able to have that opportunity with you.
I think as an entity who supports children and in an advocacy role, what we find is when we develop, for an example, an independent living plan, if those young people have been in court and they have participated in that plan, they own that plan, and that empowerment is huge. Mm-hmm. It's absolutely huge, and it also allows us to maintain a relationship with our youth. So when maybe they come out of a courtroom situation, they've been in that hearing, they don't understand something, they feel empowered to call us and say, hey, at the next hearing, would you write down this and remind me that we need to talk about this? Just that ownership is so amazing.
Yeah, absolutely. Anything else? Yes.
Well, I was just going to say, and this isn't anything that I thought of or anything, but I've heard it before as well, but just that part about the kids knowing exactly what's going on and them seeing that it's kind of that reality check where they can, sometimes they're told by their parent or by the guardian ad litem or by a caseworker what went on in court, but if they're there to really see what went on and no one else can pull the wool over their eyes and say, well, no, this is what's happening, because they were actually there to see it.
Absolutely. Yeah, so an understanding of the process can really be enhanced by attending the court hearing. And then afterwards, though, I mean, what we're talking with the guardians ad litem about is that they do have a responsibility for, after the court hearing, having a chat with their client about these are the things that happen, and then even doing follow-up a couple weeks down the road, calling their client, do you have any questions about it? Because I think that understanding starts prior to the court hearing, but then it is emphasized at the court hearing and then again afterwards. So this is absolutely a whole process. Any other? Yes.
I do think it's important for kids to come to court. I run the CASA program in Omaha. And so in our cases, we'd really encourage as many kids to come to court as possible. But what we've done and we found is some of our kids who haven't been to court or do go to court are scared. Even if they've had a good experience, it's still very intimidating. So what we've done in Omaha is we're bringing therapy dogs in and having them either in the lobby when the kids come up or sometimes in the courtroom, just for even regular hearings. Or if kids have to testify, we'll bring the dog in and let the dog in the courtroom. On some of the courtrooms will allow the dogs and some don't. But even if the kids meet the dog in the lobby and get to pet him before and after the hearing, it just changes the whole dynamic of everything. And I've even noticed even dogs in the courtroom, everybody's nice to each other when the dog's there. They are. Everybody's like, oh, the puppy's here. And so nobody's arguing and fighting and everybody gets along. You know what I mean? It's great. So that's what we've tried to do and it's working.
Oh, excellent, excellent. You know, and on that note, we've also heard that isn't a dog, but that some kids, you know, want to have a support person that is present there, and having the court kind of open to that, open to having a person there who they can turn to is often helpful for the youth. Any other? Okay. Now I want to just touch just a bit on concerns about having youth in the courtroom. I'm not standing up here saying, you know, everything's all great. That there are some concerns about having youth in court, and I just want to start talking about them and try and address them from your perspective. Any concerns that you all have? Everyone's great with kids coming to court. All the kids are coming to court. Yeah.
You know, we've also seen some cases where there might be some really sensitive issues being discussed in the courtroom. And so what we've done is like do the basic work while the child's there and then maybe ask the child to leave or have somebody pull the child out if something really sensitive is going to be discussed that we don't want the kid to have to hear or have to deal with. Okay. So we've done that.
Okay. So things like, I think the concern I kind of heard in there is that there is going to be possibly things that could upset the child that we talk about. For example, of parents' drug or alcohol use, or or the abuse that had occurred, or some issues that could be harmful to the child. So you had your hand up. Go ahead.
I want to comment on that. We personally have seen so much stuff in our homes that going to court in a legal situation like that doesn't scare us as much. Like you guys going from usually really good homes and stuff like that, you'd be like, oh, I remember when I was that age, I probably wouldn't want to be in that situation, where we've seen our parents do drugs, we've seen our parents beat each other, we've seen all this right in front of us as we've grown up, so we're used to that. And even if it came to the point where it was kind of an iffy situation, you were concerned about it, have the kids pulled up to the bench and say, hey, we're going to be discussing some of this about your mom or something. Do you want to stay in here or do you want to leave? It's up to you. And let them know what you're discussing, because then they know what they're missing out on. Not that you guys are just like, oh, go out of the room. Because then it's like, well, what are they talking about in there? Why can't I be in the room? Is it about me or what? Where if they get to know what's going on, they can choose if they're willing to stay in there. And some kids rather hear that their mom and dad aren't doing what they're doing and sit there and be like, well, Mom, you've lied to me over this. You keep telling me that the judge is not letting me go home because you're doing everything and they just don't want me to go home. And then you have this person sitting in front of you saying, you have not passed your UA. This is why your daughter's not coming home to you. Where it's just good to hear it from someone that higher power than hearing your mom, because you always trust your parents, no matter, if they do something wrong, you always love them. They gave birth to you. So.
All right. So I think I kind of see two things here in their levels is that we should be careful about when we say a particular topic that is going to harm kids. I encourage us all to sort of raise the bar and have a fairly high standard when we talk about what issues a child can't hear. And I think that that's a good idea, having the child approach the bench and having a discussion about these are the things we're going to talk about, giving the choice to the child. But there are going to be things that the judge and those of us in the room, the advocates, think that it would be best for the child to not hear. And in that case, I think it's fine to kind of split the hearing, have the child come in, have a discussion about placement, about permanency, about school, again, sort of establishing, the connection that you two talked about, and then having the child excused from the courtroom if you want to talk about things that the child might not be good for the child to hear. Yeah.
Just following up on the comment there, though, it seems that children, at least if they're going to be excused, deserve to have some general concept of what they're missing out on, because otherwise they're going to be out there thinking probably far worse things than
That's
what
true.
do you agree? So like how would a judge explain that?
Yeah, I mean, I think that there are, there was one guardian ad litem in the other workshop that said, if we have a case where there are two kids, a brother and a sister, and you have one child that has, very different kind of abuse or kind of needs as the other child, and the other child does not want his or her brother to hear about it. So it could be kind of an issue like that. And so, yes, and so you could have the kids approach the bench and say, we're now going to talk about the case of your brother. So I'm going to ask you to leave the courtroom. And so, again, kind of explaining so that you're absolutely right, that the child does not kind of have these wild imaginations of what could be happening in the courtroom. I think it's an excellent idea. Excellent idea. Other sort of concerns that you have?
I think one of the things that we have seen, and it depends on where we're at and which courtroom we're in, but if children and youth, especially youth, perceive that the attorneys present, most often their GAL and the county attorney, are more interested in winning than in them, that they are not the focus, that creates a huge loss of respect for the judicial system. And it creates an attitude that's very difficult to overcome if you're in an advocate role for those children. And I think it's important that somehow we educate our court officials, whoever they may be, that does have serious impact in their lives.
Yeah, absolutely. I think that it's right, that it is important that the children know, and it's true that these cases are about them, and so I think that as a judge, it's important that the judge at the outset, and I think one way to kind of establish that is for a judge at the outset to talk to the child and introduce him or herself to the child, talk to the child about school, about things that sort of create a comfort level between the child and the judge. Having the judge tell the child, you are the most important person here, that this is about you, I'm interested in your opinion. So really having, placing the burden on the court. I mean, the court is going to have to take a lot of the burden of this. And so having the judge sort of set the tone of the hearing. Sure, go ahead.
Okay, one thing too, my personal judge, like we had the Lancaster panel yesterday or whatever, and the judge had mentioned maybe he had brought in personally like soft toys for the younger kid, and you can see how the kid interacts with like one of the kids. He had a little football and he was throwing it back and forth to like all the attorneys in there, and just seeing that the kid is the happy kid, you can see how the kid's affected by things, or who like if they sit by them or something like that. You can just tell by having the kid in the room, like with all this stuff. Like it doesn't matter on age. So I had to throw that in there. I was just thinking about it.
Okay, that's okay. And it's I think that you brought up an interesting point about age, and I do want to before I get to sort of the nuts and bolts is that a lot of states do use age as sort of a criteria, and I guess I'm interested to find out what sort of criteria you as judges want to be imposed if a child is going to come to court or not, and is age one of those criteria, and what are some others?
Just the well-being of the child, be it physical or emotional. If the child's involved in therapy and the therapist gives a clear indication that this might not be good for the child, we'd certainly take that into consideration. I'd like to see the kids now, even if they're infants. If they're being carried into the room, that's I'm looking at a real child, and that's again not just a a name in a file.
Yeah, absolutely. So emotional health, I think, is also, can be one of the criteria to help us to decide not only if a child should come to court, but then how to have that child there. If it's going to be to sort of split the hearing and have the child come in and have a discussion about school and those kinds of things, and then have the child leave. And I think having a counselor or a therapist opinion sort of at the outset is important, and that means that we have to, the guardian ad litem and the caseworker, have to talk to the counselor or the therapist in advance and say that we do have a court hearing coming up, and that therapist should be involved in preparing the child for that, and also giving us input and advice as to what extent the child should participate in the court hearing. Other criteria that you all think might or should come into play?
Sorry, I'm on a roll.
That's all right.
I really don't think it should be based on age. Like, if it came to a point of having to, like, set a limit on something, I'd personally say, like, maturity level, because I know when I was at age 11, I knew that a lot of stuff that had gone on since I was young, so I know, I've seen it, I've been there, I've experienced it, where if you set like an age saying, 13, and what if they act like a 6-year-old, like, I don't think they should probably not come because they're not actually into it, where if you have like an 11-year-old that acts more like a 15-year-old, like, they understand their position. So I think it's based on maturity level where they like set their goals, and like if you can see how they act and interact with people, and if they understand, or if they can tell you how they're feeling about situations and stuff like that.
Thank you. Okay. Other kinds of criteria. Okay. Other concerns that you have about youth coming to court?
This is a question that kind of shows itself regularly. At least it's a concern in my mind, and that is anytime a child comes to my court, and I go around the horn basically and hear from everybody, but at the outset, typically I'll ask the child if they want to say anything. And every time I do that, sometimes it comes across my mind that a child may be cowed a little bit by the circumstances. They might be intimidated, that they might, sometimes I see them kind of give a furtive look around and say no, and then they're done, and I think to myself, maybe they really do want to say something to me, and this whole thing is a failure in that child's mind because they're leaving without being able to tell me what they plan to tell me. So the concern I have, and we have two young ladies here who are not very shy, and Judge McCardle's relation of his experience, that child certainly wasn't shy. Hour and a half, really? Okay. But how do we go around that? I know I have a guardian ad litem, and our guardians ad litem in Douglas County are actually quite good. They help us out quite a lot. But sometimes the child just wants to say something to the judge, and I'm real hesitant to say, come on into chambers and talk to me off the record, or maybe even on the record, because we'll have attorneys out there who might be very concerned. It's just an issue that I'm not quite sure how to deal with.
Okay. Thoughts on how we're handling it? Yeah.
One thing that helps is well, first place, read the case plan so you can see what's going on, like how are they doing in class, what grades are they doing, how well they're doing in some classes, if they're not doing well in other classes. Engage the child in things that are in the plan. If the kid has gotten student of the week, or if the kid is getting A's in math or something like that, particularly the ones that are junior high, senior high, one of the things I'll start talking to them about is the fact that it's important to do this because they need to look at going to college, and that they're setting this up right now, and get them to talking about things that I can see have happened in the case plan. They relax, and then you ask them, is there anything else? Because once you've got them talking about stuff and they realize that you know a lot about what's going on, I think they're more readily available for you to give you more information. I mean.
Right. Yeah. It's easier to answer, pointed questions about things and then sort of open it up. I think that's right.
Sometimes I get the impression that the children don't want to say something because mom and dad are sitting right up there. And that's really kind of where I have the problem.
Okay. Thoughts on, yep.
I'll have them write a letter, give it to me. So if they don't want to say it in court, let them write it down, and then let you look at it while you're up on the bench, and then you can inquire further if you need to. So that's happened for me. I just want to comment too also. I'm a judge. Just don't assume because a judge didn't maybe grow up in foster care that things didn't happen in their lives that maybe you've experienced too. So sometimes we all have life experiences, and we take them to the bench with us. And so one thing I think is I'm going to hold you guys accountable just as much as I hold your parents in some respects, because you are teenagers, and teenagers are teenagers, and I want to know if you're getting good grades. I want to know why you're not getting good grades. I want to know what's going on. So I'm going to inquire on stuff that's probably fairly, maybe uncomfortable sometimes for even the younger people. But I think you want me to treat you like that, because instead of like, soft sell it, like I sometimes feel like what we wanted here in these things is like, let's bring dogs in, let's hug, let's do all this. Well, I got to tell you, this is court, and maybe sometimes it's a little tough, okay? Especially on children who are older, who need direction. So I like to hear what you have to say, and I want you to talk in court, but sometimes one thing I always tell everybody is, I'm not going to lie to you. I'm not going to soft soap anything. Here's how this works, and I want to hear from you, but I expect some things from young people too, because even if it's a 3A filing, if you're a teenager, a lot of times you're right, we get acting out, and then we end up with 3Bs or sub 1s, and then I've got to deal with all that too. So those are things that I think as a judge, I want to hear from you, but also I'm not inclined to be always so soft. It depends on the case, or it depends on the individual. But I want your reaction to that. My impression is sometimes I think we're too soft or too afraid to deal with the realities of what's going on in there.
Hands are going. Excellent.
I think we realize when we walk into a courtroom that we're walking in to a pack of wolves, like not in a sense of like being mean, but we understand that it's not fun and games. And I think the older group, the older population, I think we want it. We want it straight, because a lot of times, like I know in my life, nobody really gave it to me like it was. They always, okay, Haley, you're very good. You're doing good. Good, Haley. Like I was a dog. I do have a brain, although you can't see it, And when a judge, somebody again in power can see that, and so I have an F in math. Well, that would be great if somebody would ask me, why aren't you trying in math? Do you just not get it? What do you need? Do you need tutoring? A lot of like my foster moms, they never did that. I never had an F in math, but I mean, things like that, like we want it. We want that, at least in the older population, and we don't want it soft coded, and we want the words so that they're like English to us, but we don't want you to sugarcoat things so that we don't get like the full thing. We do want it. We do, because like Mickey said, parents don't always tell you the truth because they want to make it sound good. You're their kids, you love them, and they want to look like the best parent that they can absolutely be. So they're not going to tell you, I have a dirty UA. Like things like that your parents not just going to tell you, but a judge would tell you that because they don't lie, like then.
Give me the current usage, because I use dope when they look at me like, okay, you need what should I be using? Give me the current usage out there. Just so I get the right language.
A lot of people say just different things.
Yeah.
Can judges be dorky and not have the right language? Is that okay?
That's okay. They're judges.
Dorky would apply to all. Okay, we gotta do something else here. So I just wonder the current usage is pot, weed, what? Both? Okay.
Yeah, pot, weed.
I wouldn't use dope in your courtroom.
Even my own daughter told me that.
It's a little out of style, like whack.
Or green. I've heard people call it green.
Yeah,
Like when I go smoke some green.
Oh, okay.
Like, I don't know. Stuff like that.
Any follow-up?
Yes. I'd have to say too, with the whole fact of you being like harsher and getting on it, it's more like a parental thing where we look up to you, like you're like acting like a parent to me. Whereas like certain placements, they just take you in for the money. Certain, like, there are people out there that do that, and they don't really care about where you go, if you get sent off sooner or later, like, and you don't have that parent figure in your life because your parents have done something wrong, you're not living with them, and going into court even just once every 6 months saying, how you doing? Oh, I see you're on honor roll, you're doing real good. And it's like, why is this grade slipping though? I noticed that one's going down a little bit. And like, just having that one person sitting there like, well, maybe we'll help you out, we'll get you to something to figure this out, we'll just figure out what's going on in your life. Just, it's like a parental thing. Like, most kids, like, and a lot of people, when they don't have that parental thing in the system, they do slip because they don't have someone putting them in check saying, hey, you need to do this. Or like, my judge, when I was coming to the age of graduating, I was asking, how are you doing on scholarships? Have you been filling them out? Like, asking me stuff like that to make sure that I'm moving on to the next step, bettering my situation instead of letting me slip through the cracks.
Yes.
One of the things that I think as judges that we need to recognize is that if you create a dialogue with kids, you create a dialogue with parents, sometimes you learn things that just simply aren't there in the case plan. And the classic example, and I get teased about this because my public defender has ADHD. I've got 2 kids with ADHD. I have educated myself tremendously about ADHD, and I'm telling you that the school systems, for the most part, don't even see it, don't even understand it. If you sit down, if you say, if I had a kid that was getting an F in math, that's immediately triggering me to start asking her questions, asking her parents questions, things like that, literally doing a screening and then saying to that caseworker, you may have ADHD here. She needs to be screened. She needs to be helped. You know, if her math facts slipped in 4th grade, it's because she just doesn't learn the way other people learn, and you need to do that. And there's a lot of different things like that that if you ask the right questions and you get the answers, sometimes you can help the professionals a lot.
Absolutely, absolutely. I wanted to real quick just go back to your point because I think it's a good one because I'm sure it happens a lot. When you have a child in a courtroom, there's everyone that's around the tables, you're up at the bench, and you say, is there anything that you want to say? And you think that there is, that the child, you know, the body language of the child is kind of indicating that there is, but the child is too shy. Sort of other ways to bring that out. I think we first talked about how, you know, to kind of start engaging the child with pointed questions about school to get the child to loosen up. Another one was to have the child write a letter. Another one I've heard is to actually have the child and even attorneys approach the bench. And so you're actually closer to the child, and I understand that your courtrooms are open, right? And so there's probably people in the back, and so having the child and the other attorneys come to the bench, sort of, it personalizes it a bit. And so instead of going in chambers, I understand your hesitation about going into chambers, although that is an option if you get the consent of all the parties to have you and the guardian ad litem go into chambers. But if you're not comfortable with that, you know, having them come up to the bench could potentially help the child to engage in a dialogue. Anything? Yep.
And the other way to do it, and I don't do it a lot, but come off the bench and get down and sit down across the table from the kids.
Yeah. Yeah.
No, I don't. Would that scare you, or would that make you feel even more comfortable? Because
a little kid, like maybe like 5 or 6, I'd look at you with this big black girl coming down here, I'm going to sit right.
No, I think that's a good idea.
I'm not talking 5 and 6.
You know, but you're talking teenagers.
You're talking to a teenager, and
right.
And I think that's my way of saying, you know, I want to be down on your level and understand what's going on here.
Like, I'm not just that big wig sitting up there having decisions, but I'm down here and want to understand.
Right. Some way to sort of equalize or even just to bring you closer in proximity to the child will often take away some of the hesitation of the child. Okay. Other concerns that folks have about having kids come to court. I wanted to just real quick bring up one that has been raised in other areas is the school issue. Is, you're coming to court, and so you're absent from school. And a lot of judges that I've talked to said, absolutely not. I'm not going to have kids come to court because we then have to take them out of school, and they're already not doing well in school. And so okay, we're going to have a comment to that. Yep.
Personally, we'd rather be taken out of school. You can always catch up on homework, but you sitting in school all day saying, I wonder what happened. Am I going to be moved? Am I going to, what's going on? What are they doing? You don't concentrate on your schoolwork if you're in class. You sit there the whole time and you're like, what did they do? Am I going to have to go home and pack my bags? Are my bags packed? What's going on? You do not concentrate one bit. You watch the clock until school gets out. You do not, you'll just, sit there and just be drawing, saying, oh no, freaking out. So I think it's better to take us out for that 5-10 minutes, or if you have to drive, whatever time, because the kid will always catch up knowing knowing where they're going to be. They'd rather have that.
And I think, again, if you don't with excusing the kid from the courtroom and you don't tell them why you're excusing them, the imagination just runs wild, wreaks havoc everywhere, in every corner of the mind. The imagination finds it, and we create some things that you would think are dumb. Why would you even imagine that? But if we don't know, we don't know, and so we imagine something to take the place of that. And like Mickey said, we're anxious, we have anxiety too, and we mentally won't be at school anyway. I mean, school has always been my sanctuary, but if I didn't get to go to a court hearing, when my mom was still alive, I wasn't at school. I was physically there and I was present, but I wasn't thinking about what 4 + 4 was, or the square root of 2. That's not where my mind is. It was on what is gonna happen, what's gonna happen with my mom. Can my mom take me home? Do I have to stay with so and so? Our imagination gets the better of us sometimes, and if you don't let kids know, and I can't imagine what somebody in elementary school would imagine. All the TV shows and stuff,
Thank you. Yes.
I hate to dominate, but one of the things I do is, my review hearings are always after 3:30.
Absolutely.
And I'll literally, if I don't know the kid or if it's early on, so what time do you get out of school? That way, at the worst, they're going to miss one class maybe.
Right.
And it also makes it easier for the parents if you do it late in the day, because a lot of employers, will let those people come right at the end of the day, but if you try to stick it in the middle of the day or in the morning or something like that, it cuts the heart out of their day. It makes a problem for them too. So if we go past 5 o'clock, we go past 5 o'clock. It's as simple as that.
Okay, yes.
As the wife of a veteran teacher, and it is that scary high school math teacher, and having been a foster parent as well, my husband would always prefer that the children be allowed to go to court, and he would spend his time helping them catch up. He would say exactly what you said. They're not paying attention anyway. They're afraid. It creates issues that I would much rather not deal with. And if I have to stay after school and help them catch up, okay, I'll do it. We need to ask some teachers.
And another thing I think is important, that'll only happen though if we inform the schools in advance. And so I think that the burden really has to be placed on the guardian ad litem and the caseworker to be able to contact the schools and ensure that they understand that the reason this child isn't going to be at school is because of a court hearing. And then it's important for the court to be aware of big standardized tests, that you're not going to schedule hearings when the child has to be in school because there's a test that has to be taken. And there's spring break, there's fall breaks, there's a lot of things that the court needs to be taking into account when you schedule these court hearings. Okay, any other before we sort of move on? Okay, and so this slide really talks about what should happen at the beginning of each and every court hearing. And the purpose of this is really to place the emphasis that you feel that it is important to have children in the courtroom, even if it's clear that there's a child that is that is present, asking, is the child present? Introducing the child, yourself to the child. If the child isn't present, asking, how come? Where is the child? Is the child aware that there is a court hearing? Was the child given transportation? So again, really ensuring that everyone knows that you place an importance on the child being present. And then even asking if the hearing needs to be postponed to have the child present. Has the child expressed an interest in being there and then couldn't get there because of transportation? If so, continue the hearing. And I understand that there are issues with timelines and trying to achieve permanency quicker. But if you continue these hearings early on, then you show the importance placed on it, and then people will make more of an effort to get the children present. And then finally, and almost most importantly, document it in the court order. Document if the child is there, and if the child isn't there, why? And put that in the court order. And then at the end of the court order, and if the child isn't there, say, I would like the child present at the next court hearing. And so again, really indicating to all of the parties involved the importance that you are placing on kids being present. Now, I saw that you brought these. So these are bench cards that we are giving to each of the judges, and they are broken down by age. And so it's when you have a child comes to court, here are some of the things to sort of look at, some questions that you can ask that we have come up with. And so we're going to give those all to you. And so these slides are kind of imitating those. And so I'm not going to go through each of the slides, but I did want to just ask, because we did have some questions in the prior session about bringing infants and toddlers. And so I want to get an idea from you all about that. Do you think it's important to have sort of, I think we've talked a lot about older kids, and I think as we talk about coming to court, we emphasize that. But let's talk about, just for a sec, younger children and even infants. Do you think it's important? And if so, what is your role as a judge when there is an infant present?
Like the gentleman over there in the blue said, it's putting a face to a name on a file, and I think it's important, just every 6 months, not every single hearing that the infant or the toddler needs to be present, but to see that they're growing, that they're maturing, that this is a human being. It's not just a number. It's not just a file name. It's not just another case in my day. I think that is important, for the judge's benefit. The infant or the toddler doesn't necessarily get anything out of going for themselves, but, like we talked about in the previous session, that can help parents. You can see the interaction between the parents or the caregiver, whoever, and the child. If the child runs towards biological mom, or if they stay, next to foster mom, like things like that you can just pick up on. You don't even have to ask anything. You can just see it.
Observe the child.
Yeah, and you can, like Mickey said, that guy had a football and he was throwing it, to the attorneys around the table. And, okay, so it's not, something that's normal in a courtroom, but you can see that he's happy that he can throw a ball now, and when maybe 6 months before he was just learning to do that. Things like that make cases more real to a judge. And I think sometimes that is more important than actually what's being discussed at some of those hearings.
And I'd say too, even if the child couldn't come all the time, updating pictures with the file, like pictures, seeing that this kid is growing up, so that you see where you're you have a picture 6 months ago. Oh my goodness, that's a long time in a little kid's life. You get from when they're infants to when they're starting to wobble around on the ground. That's a big difference in life. And pictures, at least, to see this kid's growing up, and we need to do something about it.
Other thoughts about what your role is when there is an infant present. I think it's important, as you both said, to really observe the child interact with the other parties, with the parents, with the foster parent, even with the guardian ad litem. And there's also, does the child appear healthy and appropriately interact? And I caution against any sort of conclusions based on what you see, but what I encourage is that if you're at all concerned about where the child is in terms of milestones, that you then refer the child for a screening or for some sort of testing. And so again, it gives you just another person to lay eyes on this child to see kind of where they are in terms of their growth. Anything else? Any other? The same kind of things with toddlers. Again, there's not really a lot that the toddler is going to gain, but what you as a judge can gain from actually seeing the toddler, again, interact. But you can, having sort of toys available, or if you are going to talk, if it's an older toddler, if you are going to talk to the child, using very, short words, keep things very short and concise, and asking the child, do they understand? Or asking the child to sort of repeat back to you what you have said. The other thing is important is, again, if they're older toddlers and you are going to talk to them, using people's names instead of a pronoun, instead of he and she, so that the toddler kind of understands it. All of these are broken down on the bench card. So I'm not going to go through all of these, but again, these sort of sample questions that you can ask. Again, just establishing a rapport between you and the child. Again, just more questions. Okay. And we talked about sort of what kinds of things, what kinds of criteria to take into account when you're going to decide if it is indeed in the child's best interest to come to court. And then I wanted just to real quick, as I don't really think I have a ton of time left. We were just in the previous workshop, and I always, and I just have to say, in all of my presentations around the country, I talk about the fact that we don't have a ton of studies done about the impact of court on children, and a lot of the judges, when I give talks, say, I want to know some concrete data about the impact. Does this really help kids? Are kids harmed by it? And now I can say, yes, we do. And so, but I, and so, you guys can comment, a ton more than I can. But I think in the short time that we had is that kids overall, there was no finding of harm to children when they came to court, and the ages, that was almost 8 until 18. So they observed hearings as well as talking to kids both after the hearing and then even a couple weeks later, talking to children, and there was no evidence of harm, and actually there were some positive things that came out of it, and even comparing kids that did go to court and kids that didn't go to court, sort of their view of the judge, their view of if they felt the judge had all of the information to decide things. Kids that did go to court felt stronger about that yeah, they would trust their judge because they were present. But kids that didn't go to court, they didn't have as strong feelings about whether or not all of the parties there had enough to decide. And I think that these are critical. And I'm sure that you can get all of the the results of the studies from Vicky, if you would like. So this is my contact information at the end. And so if you have any questions or follow-up, please feel free to contact me. And I just want to, and I think each time, whenever I do these talks, I usually don't do them unless I have former or current foster youth present, because I can stand up here and talk about my clients for hours, but it's really a whole other thing to actually have the youth present. But every time they kind of share a part of their story, they share a part of themselves with you. And for that, I just want to give them a round of applause. And so thank you all for coming. So you
Thank
can.
you, Andrea. Yeah, why don't we just there are 6